So good morning, everyone, and thank you for joining us for our first webinar of 2022. It's a lovely sunny day, as you can see out of my office window here. I hope the same for you. It's hard to think that we're already in March, but it's really been quite a year, a challenging year. The uncertainty in global politics and, of course, the war in Ukraine have rather dwarfed other news in the last few weeks, including, of course, the number 10 parties and the government's plan for living with COVID-19. One of the things that's changed over the last 2 years is the increased expectations that employees now have around wellbeing issues. In particular, the pandemic has shone a light on flexible working, on work-life balance, and also the support that employers can offer their staff. One area of wellbeing focus recently has also been the menopause and the significant impact that it can have on women at work. We are certainly experiencing a recent uptick in allegations of discrimination too made against our clients, and we're going to look at those themes this morning. I'm really pleased this morning to introduce you to Kim and Grace, who we welcomed to the Fox Williams employment team last year. This is their first HRLaw webinar, and you will definitely be seeing them again in future webinars, and hopefully have the opportunity to meet them in future in-person events. Now, I want to make a particular mention to Kim, who unfortunately has tested positive for COVID. So if she needs to drop off after her session and shut down her camera, it may be because she's having a coughing fit or something. So we're really grateful to Kim for making it to the session this morning. She's going to start today's webinar with a discussion on how to recruit and retain staff in 2022 in light of what has become known as the Great Resignation. I'm then going to talk about how best to support your employees through the menopause, as well as whether they might have some legal protection, such as a discrimination claim. Grace is then going to focus on the reasonable steps defence, which is available to employers who face a discrimination claim. And she's going to talk about why it's important and the things that you as an employer can do to put yourselves in the best position to raise the defence should it be needed. And finally, my partner Sasha is going to update you on recent immigration law developments, of which there are many. Sasha will also touch just very briefly on the immigration assistance that might be offered if any of your staff, candidates or their families are affected by the crisis in the Ukraine. Now, as ever, if you have any questions, please do pop them in the Q&A function, and we'll cover as many as we can once we finish. We'll have a hard stop at 10, so you can all get on with your working day. If we haven't covered all the questions, then we're happy to drop people a line and cover those in writing afterwards. We will be recording the session, and the recording will be available shortly on our website. So if you wanted to share it with your teams, please feel free to do so. Now, as usual, we thought it would be a good idea to run a short poll before we get started. So Jess, please can you put this up on the screen now? It's entirely anonymous, so just a chance to see whether others are taking a similar approach to you. So the first question in our poll is whether you currently have a policy in place for supporting employees through the menopause. The second question is how often do you run equal opportunities and anti-harassment training for your staff? And then thirdly, whether you're planning to recruit staff to the UK from overseas in 2022. I'll give you a moment just to pop in your answers there, and then Jess will put them up on the screen so we can see the collation of the results. Okay, Jess, do you want to pop them up for us? Okay, so interestingly, only 16% of you have a menopause policy. Some of you doing equal opportunities quite frequently, and quite a number of you planning to recruit from overseas. So some interesting results, we'll pick up on those in the sessions. So with that, I'm going to hand straight over to Kim, who's going to talk to us about the Great Resignation. Thank you.
Thanks, Jo. So as Jo said, I'm going to be talking to you about the quite grandly coined Great Resignation that I am sure that you have heard or read about recently. So the first question, is it really happening? Well, the statistics would certainly say so. We're currently experiencing the highest rate of UK employee resignations in over a decade, with the lowest redundancies since the mid-90s and the level of open vacancies the highest on record. And why is it happening? Well, for many, it seems to be as a result of a career and lifestyle reevaluation, particularly on the back of the COVID-19 pandemic, which arguably brought what's important to people into sharper focus. There's also been an increase in employee burnout, and of course there is the idea that the grass is greener, with employees moving for seemingly better work opportunities and in many cases an increase in pay. In terms of the trends that we are currently seeing in the market, there's certainly an increase in employee leverage in respect of pay and bonus reviews. The employee market is particularly hot at the moment, and the remuneration packages being offered by competitors are sometimes too generous to turn down. That then ties in with an increase in enhanced remuneration packages that we're seeing for existing staff, which are aimed at encouraging loyalty and trying to ensure that the talent stays within the business. There's also been an increase of employees relocating outside of London, though I should say that I actually did the opposite and moved from Leeds to London last year, but that certainly doesn't seem to be the trend. With the ever increasing popularity of flexible working, employees are taking advantage of that and have moved outside of the city. Where there are hybrid working arrangements, we are seeing a reluctance to attend the office for more than a few days a week. People have gotten used to working without the inconvenience and a cost of a commute and the effect that that has on their work-life balance. I'm aware of one business who has required all of its employees to return to the office full time, and they are facing considerable pushback, and we think it's likely to have a detrimental impact on their retention rates and future recruitment prospects as a result. So how can you recruit talent in 2022? Well, firstly, it's important to consider what employees are looking for, and we've included a few of the main themes we're seeing at the moment on the slide. Jess, I think if we could just go one more forward, please. Thank you. Yeah, great, thank you. So first and foremost, there is this renewed importance of a work-life balance. So employees are no longer tolerating a sort of work hard environment. There is a much stronger desire to maintain those boundaries between work and home life. And that ties into the ability to work from home and hybrid working arrangements. So that's a theme that we are seeing very strongly in terms of what employees are looking for. And recent commentary suggests that many female candidates, for example, are being put off of roles where they think that there's no flexibility on offer. So it's therefore important that if there is the ability to work flexibly, that's highlighted in the recruitment process to make sure that you're accessing the widest pool of talent possible. And it's also important to advertise flexibility to both female and male candidates so as to remove the gender stereotype barrier. Market leading employment packages are another thing that employees are looking for, which perhaps goes without saying, but it's unlikely that higher salaries alone would be enough. Employees are also looking for a supportive culture. ESG is building traction, and businesses' consideration of employee well-being is high on employees' agendas. Employees are also keen to see that there are training and development opportunities to help better themselves and their offering, and having a clear career path for your roles is a great way to attract talent and to inspire loyalty. So what can you do to recruit talent in 2022? Brilliant. If you get out there, demonstrate what it is that you have on offer for employees. If you have a focus on well-being or ESG, then make sure that you say that and that it's out there and well publicised. A really good example of this was Virgin Money. Last year, they announced a new benefits package. It included equal parental leave, 30 days of annual leave and 5 days well-being days, as well as removing all geographical boundaries for their non-store-based job roles. And that was picked up and widely publicised in the press, and that was attractive to candidates as a result. Widen your talent pool. So with the move to hybrid working arrangements, roles that were previously inaccessible may now be much more accessible to certain candidates, such as those with disabilities, for example. Older workers are one of the fastest growing sections of the UK workforce. So tapping into those talent pools that other businesses are not yet tapping into will assist in ensuring that your business is maximising its opportunities, and it also demonstrates that it's a welcoming environment for all. Ensure that your recruitment process is fit for purpose. So we're seeing commentary at the moment that suggests that employees want a shorter, sharper process rather than a long, drawn out and protracted one. The lengthier the process, the more chance there is of getting it wrong. And it's of course important to ensure that your processes are non-discriminatory and avoid discriminatory language and questions that are prying into family life, for example. It's also important to ensure that the questions that are asked of candidates are consistent and don't change depending on your own perceptions. The final note on the slide is just one of caution. Where recruiting from competitors, you do need to be careful that by doing so, you won't be on the hook for inducing a breach of contract. If restrictive covenants are common in your industry, you will be expected to ask the question whether a prospective employee is prevented from joining. You can't simply bury your head in the sand, as it could leave you legally exposed, and we would suggest that you contact us for advice if you are ever unsure. On the next couple of slides, we've set out some of our top tips for retaining talent in 2022. First and foremost, and perhaps the most obvious and sort of the theme that we keep coming back to, is increase in remuneration to retain key performers. Now, as I said, that's not to say that salaries alone are going to be enough, but they can make up part of a well-rounded package. It's important to ensure that you avoid gender pay gaps when you are making increases, that you use fair, objective and performance-based criteria to justify any salary hikes that you are making, and make sure that your managers are trained on best practice in these scenarios. Boost diversity and inclusion. It's no longer something that's desired by employees, but rather it is expected. And for those of you who work in a regulated sector, regulators expect it too. We've seen a massive emphasis on D&I in these arenas, and showing a commitment to diversity and inclusion is likely to be well received by your employees. Create a positive and supporting environment. In the current climate, employees are quick to quit the job they're in if they're unhappy, and a good culture and environment is an integral part of employee retention. Take steps to enhance your office space. Many businesses were actually quick to reduce their working spaces as everybody moved to working from home at the start of the pandemic. But what we're seeing is, even in hybrid working arrangements, employees are wanting to attend the offices, and there is a higher expectation of the functionality of such spaces when they do so. Examples of how you can enhance your office space are breakout and collaboration spaces and subsidised canteens, for example. Consider implementing employee perks. So free yoga is a good example of this. Wellbeing initiatives such as guest speakers talking about motivational and relevant topics. You may also want to think about a specific budget per employee for wellbeing spend or wellbeing days in addition to annual leave days, which is a couple of things that we've seen businesses do recently. It's also helpful to think outside of the box in terms of how you are engaging an individual. Whilst employment may be the most mainstream and common option, you can engage individuals on consultancy arrangements, and that could be attractive to high performers that want much more flexibility and would allow you to retain their talent on a consultancy basis. There is, of course, the added possibility of remote working and being flexible about your employees' location, even allowing them to work from abroad. There is a slight cautionary note on this for engaging staff overseas, as there can be complications where individuals represent the business in another country, along with tax implications. On the final slide, I'm just going to talk a little bit about things to watch out for at the moment. I'm sure it's no surprise that one of the themes that we have picked up is flexible working, which I know that you've heard from us on recently, but I'm sure is high on your agenda. The first thing to say is that flexible working is very much here to stay. As I mentioned, businesses that are seeking to move back to a pre-pandemic 100% office-based structure are facing considerable pushback. In light of this, it's important to consider how flexible working will work for your business moving forward, and it may also be appropriate to look at your policies and consider whether they need updating. There is, of course, a difference between flexible hybrid working arrangements that we're seeing at the moment and an employee making a flexible working request under the statutory regime. As you'll know, the statutory process remains as it has for some time, and employers are required to deal with such requests in set periods. The case law on flexible working requests makes it clear that such requests do need to be handled correctly and proper due consideration given before any request is rejected. If requests are not properly considered, there are potentially expensive claims to be made, particularly in the context of women who have childcare responsibilities. There's also the government consultation paper entitled Making Flexible Working the Default, which proposes to make flexible working a day one right. The response to this consultation is currently being considered, and it was certainly one to watch out for. That's all from me. Thank you so much for listening. I'll pass you on to Jo, who will be speaking about menopause at work.
Thank you very much, Kim. So I'm going to talk about menopause at work, as Kim says, and the support that you as employers can offer to employees going through it. I'm also going to look at whether employees with menopause or perimenopause symptoms have any legal protection available. I think the starting point is to think about why it's a good idea for employers to engage with this issue. And as a woman of a certain age, I admit to a vested interest in this. So the government has previously reported that women aged 50 plus is the fastest growing section of the UK workforce. And what that means in practical terms is that more women than ever before will experience the menopause transition through their working lives. Now, unfortunately, the menopause is one of those subjects that people can feel uncomfortable talking about, which means that many women won't mention their symptoms or the resulting difficulties they're having at work to line managers or even colleagues. That may either be because of embarrassment or because they feel that there's unlikely to be any sympathy or understanding on offer. The lack of awareness that employees may be struggling with the menopause can in turn lead to negative assumptions being made, particularly, for example, if an employee's performance dips or their behaviour at work changes, or if they're taking more regular time off as a result of menopause symptoms. Now, the menopause itself is generally defined as the period when menstruation ceases, and how long that can last obviously varies enormously, and for some, symptoms such as hot flushes can go on well past the last menstruation. Menopause normally occurs between the ages of 45 and 55, but the UK average is aged 51. And that, of course, coincides with the age when many women have reached senior roles, having invested many years in their careers to get to that point. And also not forgetting the fact that it can also coincide with having teenage children, and I can verify that that is indeed a very stressful time in life, and also increased caring responsibilities for elderly parents. So it can for many be a period of significant stress and anxiety in their lives. As you probably know, the stage before menopause is known as perimenopause, and that can begin much earlier than the menopause itself and last many years, but often involves similar symptoms. And I've just given some examples of those symptoms on the slide. But I think as Sasha mentioned to me once, that a friend had told her that she was told by an expert that pretty much any ache and pain you have over age 50 could be a menopause symptoms. And some of those symptoms, such as depression and anxiety, won't necessarily be identified and recognised as symptoms of menopause by the employee, let alone their employer. It's also, when you look at that list, not hard to see why these symptoms may have a detrimental impact on an employee's working life. And the Women Inequalities Committee has just reported survey results which show that nearly a third of women have had to miss work due to their symptoms. One thing to keep in mind as well is that it may affect a wider cross-section of your workforce than you imagine, including non-binary and trans employees, as well as, of course, of younger employees, for example, who've undergone certain medical treatment or who experience early menopause. Now, the menopause is certainly a topic that's gained momentum recently, thanks to the likes of Davina McCall and Mariella Frostrup speaking openly and publicly about their own personal experiences. And there are now several sources of information and employer guidance available. ACAS, for example, have produced menopause at work guidance, which is a useful starting point on how to have appropriate menopause-related discussions with staff. The government has also announced a new menopause task force, which is going to meet every 2 months and tackle issues such as access to treatment and ending the stigma around menopause. It's also commissioned an independent report on menopause and employment, how to enable fulfilling working lives. And the report makes recommendations and lists useful resources for employers such as the CIPD Menopause Guide. The Women Inequalities Committee, who I mentioned earlier, is also holding an inquiry into menopause in the workplace, and that's recently taking evidence from a variety of stakeholders, so we await their conclusions with interest, particularly as to whether they see a need for the law to be extended to provide specific menopause protection, and I'll mention that in more detail shortly. If I could have the next slide. Thank you, Jess. So why is it in your interest to engage with this issue? Well, First, the statistics demonstrate a high dropout rate from work for affected women. So it's been reported that 23% of women consider giving up work, and 1 million women have already done so in the UK as a result of their symptoms. A high departure rate means that employers are losing the industry knowledge and specific skill sets that their senior employees have built up over the course of their careers, as well as the ability to take advantage of the networks they've established among colleagues and clients. A lack of senior women can also negatively affect how a company is perceived and impact its market reputation. As Kim has highlighted, employee wellbeing is an important part of an employer's ESG footprint, and it's often crucial for recruitment and securing the best talent. Candidates are very much interested in businesses which genuinely value their people at whatever stage of their career, rather than simply paying lip service to diversity and inclusion issues. With less women at senior levels, employers may also struggle to meet their own or their industry-wide diversity targets and to demonstrate a genuine commitment to gender equality. There will also be an impact on their gender pay gap, of course. So expectations are high in this regard, particularly when it comes to industry regulators like the FCA, also as Kim mentioned, where there's currently a real push towards maintaining positive and inclusive cultures. Culture, diversity and inclusion genuinely being regarded as a matter of regulatory importance now. So if I could have the next slide, please, Jess. Thanks. So you may be wondering, where do we stand legally? Now, the starting point is an employer's common law and statutory duties to protect the health and safety of its employees. And that includes identifying the specific health risks that may be faced by employees experiencing the perimenopause and the menopause, and working out what is needed to alleviate such risks and to create a safe working environment. Now, as you probably know, the Equality Act 2010 doesn't currently offer specific menopause protection to employees, although that is something that the Women in Equalities Committee are looking at. So there are 3 characteristics under the Equality Act which are protected and which may be relevant here. Those are sex, age, and perhaps less obviously disability. And I say less obviously really because the menopause itself isn't a disability. So it doesn't tick that box at first glance, but the combination of symptoms can of course themselves become so debilitating in some cases and last for long enough that the employee may satisfy the definition of disability for the purposes of gaining Equality Act protection. Now, currently employees who wish to bring a tribunal claim based on the menopause will need to show that they've been mistreated in one or more of the ways which are set out on the next slide. And that it's related to their sex or their age or a menopause-related disability. So they would need to show that they have been directly or indirectly discriminated against. In other words, that they've been treated less favourably by their employer, or their employers pursued a policy or practice which puts menopausal employees at a particular disadvantage. They would have to show harassment, for example, inappropriate behaviour by a colleague or offensive comments from a line manager which relate to the menopause. Victimisation would apply where the employee has raised a complaint about the way they've been treated or issued a claim and been subjected to a detrimental treatment as a result. And finally, constructive dismissal, which applies if the employee can show that they've resigned in response to behaviour by their employer, which has been so bad that it's fundamentally breached the employment contract. Now, the legal risks can crop up in a variety of ways, including from the way you manage employees experiencing the perimenopause or menopause on a day-to-day basis. There's likely to be a lot of crossover with your existing HR policies. So if there's increased time off work due to menopausal symptoms, that will engage your sickness absence policy and should be managed in the same way as for any other employees who are off sick. Symptoms such as concentration lapses, which cause performance-related issues, need to be dealt with under normal performance management policy and procedures. But I think it's really important to follow the ACAS guidance, and I suspect what's in many of your performance-related or disciplinary policies, which is that you should start with an informal conversation in any performance-related concerns, because that gives you an opportunity to try and get to the bottom of the problem in a less confrontational way, and may reveal very early on that menopause-related symptoms could be underlying the issue. You certainly need to be particularly alert where performance has been fine and then uncharacteristically drops. Processing sensitive medical information about an employee's health and menopause symptoms will need to be done in accordance with the GDPR and data protection obligations. So make sure that your processing complies with your data protection policy. And of course, reasonable adjustments may be relevant. There's a legal obligation to make them if a menopausal employee is deemed to be disabled for Equality Act purposes. But in any event, I think it's a good idea to think about easy win adjustments you can make to help employees cope with symptoms and stay in work. Now, just to look at on the next slide at some of the legal claims that can crop up if things aren't handled appropriately. I've given 3 examples on the slide, but actually we're seeing an increase in the number of menopause-related cases. So, for example, there were 10 cases in the tribunal in the first 6 months of 2021 alone. So the Bon Marché decision shows the danger of not addressing workplace banter. The employee had worked very successfully in retail for 37 years at the point that she started to go through the menopause. And her male manager demeaned her in front of younger colleagues, calling her a dinosaur, including in front of customers, and unreasonably criticized her by saying that her menopause was why she couldn't staple paper together, for example. Now, following a subsequent breakdown, she was eventually awarded £28,000 in discrimination compensation, which included an award of £18,000 for injury to her feelings. In the recent Rooney case, the Employment Appeal Tribunal held that a tribunal had been wrong to conclude that an employee was not disabled. Her disability claims were struck out by the Employment Tribunal despite the comprehensive list of menopause symptoms that she put forward and the details of how each adversely impacted on her day-to-day activities. The Employment Appeal Tribunal couldn't understand why the tribunal reached the conclusion it did, which means that future tribunals will need to be more open to the idea that an employee's menopause symptoms could amount to a disability if the evidence supports this. The third example is actually a case that dates back to 2012, but it demonstrates the pitfalls in relation to performance management. In this case, during a performance process, the employee had given her manager a doctor's letter explaining that she was menopausal and that it could impact her concentration. Now, rather than carry out any further investigation or make a referral to occupational health, her manager relied on knowledge he had from symptoms his wife and a colleague had experienced. He then dismissed the employee, which was in fact in breach of BT's performance management policy, and quite unsurprisingly, the employee succeeded in her unfair dismissal and in her sex discrimination claim, with the tribunal concluding that the manager would never have adopted what it called this bizarre and irrational approach with other non-female related conditions. So it's a good reminder that not a one-size-fits-all approach is suitable here. Employees are going to experience different symptoms and managers are not best placed to make medical judgments. Now, setting aside the potential legal risk for a moment, the starting point for managing the menopause at work is, I think, to break the taboo. Viewing menopause as just another life event which occurs over the course of an employee's career, much like starting a family, for example, is, I think, a positive approach. Now, the focus should be on positive conversation with employees, making sure that they feel comfortable to open up to line managers and colleagues about what they're experiencing. Increasing discussion and general awareness about menopause across the whole workforce also shows a genuine commitment to employee well-being. And we've certainly done this at Fox Williams with speakers on menopause-related topics. Now, one thing I'm very conscious of is we've not been as successful as we hoped with attendance by our male colleagues, but we're certainly working on this. Because in my view, if senior men within the business engage, it goes a long way to creating psychological safety around talking about the menopause. And of course, if senior women within the business feel comfortable talking about menopause, that can also be very powerful. I personally have always tried to be very open that when I reach up to click on my fan during a call or when my glass is steaming up, it's a hot flush caused by the menopause. And that's actually prompted many discussions and exchange of information with colleagues about how we all manage symptoms that has really helped colleagues to decide if they need to go to see their GP and also if they need any adjustments or equipment in the office. Managing the banter is important. And of course, one employee's idea of banter may be viewed by another employee as harassment. So I think it's important to make sure everyone understands that you expect professionalism and will take a zero tolerance approach. Introducing a menopause policy is another important step. And I know from the survey that some of you have done that, but many of you have not taken that step yet. A policy is a good place to explain the support and guidance on offer to employees, who their first point of contact should be to discuss issues, and also the positive way in which they can expect things to be handled. As ever, ideally, a policy should be followed up with targeted training for managers and supervisors. I think it's not safe to assume that they will all know how to have difficult conversations. It's helpful to talk them through the process, teach them the signs to look out for, and also the importance of handling things sensitively and with respect. And they should also be thinking about any helpful changes they could make for their staff. On that note, when you know you have menopausal employees, it's a good idea to risk assess for any specific issues that could negatively impact them and to identify any adjustments to their working environment or pattern that might alleviate the problems. A fan or moving a desk closer to a window can help with hot flushes, for example. A dedicated rest area or allowing more breaks when symptoms flare up may also assist. Flexible working could also be explored either on a temporary or longer term basis. If any of you have ever experienced hot flushes on a crowded commuter train in the summer, you will know how helpful flexibility about where you work and when you can travel into the office is for somebody experiencing these symptoms. And all of these things can have a very positive impact and may involve nominal cost to the employer. Finally, in terms of what you can expect if you do take the steps I've suggested, the most obvious positive is that you're likely to keep most of your or more of your female staff later in their careers. Small things can really go a long way to increasing employee loyalty and avoiding the time and the financial cost that comes with having to recruit at senior level. You're also creating an inclusive and supportive environment for the rest of the workforce, which does tend to have a snowball effect on retention rates and your wider market reputation. We know that employee expectations are at an all-time high when it comes to well-being, so supporting employees with menopause symptoms is certainly one step in the right direction. And finally, we're still at the early stage of employers waking up to this issue. It's much better to be a front runner like the 24% of employers in the CIPD poll who are now providing menopause support than waiting until you're faced with a difficult grievance or a potential discrimination claim. Now, on the note of discrimination claims, I'm going to hand over to Grace, who's going to guide you through the reasonable steps defence that's available to an employer in the context of a discrimination claim. Thank you.
Thank you, Jo. Yeah, we've just heard from Jo about the risks of discrimination claims associated with the menopause. And I'm going on to talk about a particular defence an employer might have to a discrimination claim, both in relation to the menopause and in fact in relation to any protected characteristic. And that is what we refer to as the reasonable steps defence. So the reasonable steps defence is a defence available to employers, which involves you being able to argue that in circumstances where an employee has discriminated against or harassed another of your employees, you had taken all reasonable steps to prevent that from happening. Now, before we jump into how we can use the defence, I thought it would be helpful to understand when we might actually need to rely on it. Next slide, please, Jess. So the starting point in terms of discrimination and harassment is this concept of vicarious liability. What this means is that anything done by an employee in the course of their employment is treated as having also been done by the employer, even if the employer didn't know about it or approve of it. Of course, this means we need to understand when in practice an action might be deemed to be in the course of someone's employment. And in some instances, it will be immediately obvious. For example, a manager making decisions about whether to promote someone. But in other instances, for example, chats in the pub after work, conduct at a Christmas party, these can be less black and white. Context is everything. Was the incident on the employer's premises? Were the individuals on duty? Were there other employees around? And I've put a couple of examples here so we can think about how it might work in practice. So anti-Semitic banter in the pub. Now, if this is a team outing after work on a Wednesday, it's far more likely to be deemed in the course of employment. But if this is colleagues who bump into each other on a night out in their local on a Saturday, it may well not be. And similarly, a sexist social media post might clearly be deemed to be in the course of employment if it's on the employee's LinkedIn page, or worse, the employer's own page. But if it's on an employee's Facebook page on their own time and just happened to be spotted by a colleague, it might fall outside of that. And ultimately, the dividing line isn't clear. But in many cases, the first step of a discrimination claim will be giving careful thought to whether the employee in question was in the course of their employment when the incident took place. On the assumption that they were, an employer is likely to be vicariously liable for any discrimination committed, but there are a number of defences an employer can run, and one of them is the reasonable steps defence. That is, that you took all reasonable steps to prevent the employee from committing the discrimination in question. Now, it's worth saying that bringing this defence is a last resort. There are alternative and probably preferable arguments to bring, such as the events themselves didn't occur, or the events did occur, but they didn't constitute discrimination. By saying that you did all you could to prevent your employee from committing the discrimination, You are in effect distancing yourself from the employee rather than standing behind them, which can rather throw them under the bus. And you're also placing the burden on you to prove that you did take all reasonable steps. But there may be circumstances where it's just not realistic to argue that the events didn't occur or that they weren't discriminatory. For example, you've got an employee caught on camera saying objectively discriminatory things to another employee. And because of this, it's worth understanding how the defence is run and how you as an employer can be best prepared to run it if you need to. Now, I've noted on this slide that we do expect this defence to also apply to the new duties on employers to prevent sexual harassment and third-party harassment that are currently being introduced by the government. So these principles can be taken forward in respect of those potential claims as well. Now, looking at the defence itself, and you can see how it might be formulated by a tribunal at the top there, we can immediately see that it's going to be quite a high bar. It's not enough to have taken 1 or 2 steps. You need to be able to show that you've taken all reasonable steps you could have to prevent an employee from committing discrimination. And importantly, it won't form part of this defence to show that you've acted reasonably once the discrimination has taken place. For example, you may well have responded very well to the complaint in question and investigated it properly. To rely on this defence, you need to show that you took all reasonable steps before the discrimination took place. So these are things that you should be thinking about now. So what kind of steps are we looking at? Next slide, please, Jess. And helpfully, the Equality Act itself doesn't give us any suggestions, but the European Human Rights Code of Practice does set out some guidance. Now, these steps include implementing an equality policy and keeping that policy under review, up to date, and with relevant examples. Ensuring workers are aware of the policy and what it says. It's not sufficient to simply have one if people haven't read it or don't know it exists. Providing equal opportunity training, and I'll come back to that in more detail later. And dealing effectively with employee complaints. I mentioned that actions after the incident in question won't be taken into account, but if you can show that in the past you've dealt with complaints properly, this in itself will demonstrate to employees that discrimination and harassment is taken seriously and not tolerated, so it should act as a deterrent. We're also expecting to receive some further guidance in the new Code of Practice on Sexual Harassment, and no doubt our HRLaw updates will cover this when it does, so do make sure you're signed up to receive those. Case law is more helpful, and I wanted to touch briefly on a case from last year, that's Ale and Gellen, that did give us some helpful guidance. Mr. Gellen was a man of Indian origin who brought a claim for racial harassment after a colleague made racist remarks to him, such as that he should go and work in a corner shop and drive a Mercedes like all Indians, and asked why he was in the country. This was investigated by the company, Ale, and the investigation concluded that those remarks had been said on a regular basis and that they'd been heard by their other employees but not reported. Ale tried to bring the reasonable steps defence and relied on the fact that it had an equal opportunities policy and had given equality and diversity training to its employees. But the tribunal concluded that Ale hadn't taken all reasonable steps. It found that the training that had been provided was stale. It had been given over 18 months before Mr. Gellen had even joined the company. The policy didn't make any reference to harassment or race. The individuals involved had attended the training, but thought the remarks were just banter and didn't take any action. But what this case showed us is that simply going through the motions of getting a policy and giving training itself isn't sufficient. You need to think carefully about whether that training is actually effective and how long it will last for. The judge made quite an insightful comment in the Ale case. He said, if training involves no more than gathering employees together and saying, here is your harassment training, don't harass people, now everyone back to work, it's unlikely to be effective or to last. Having said that, reasonable steps means that the defence is caveated by reasonableness. So you're not being required to take entirely impractical and expensive steps. And when we're thinking about what steps would be reasonable, case law has given us some guidance on the factors that will be relevant. I've set them out on the slide there. So the likelihood of a step being effective, i.e., is it actually something that would make a difference? The cost of taking a step and the practicality of taking such a step. So all this together, I've set out some practical tips for you as employers. Of course, these aren't just so that you can rely on the reasonable steps defence. They're also helpful practices for you to do all you can to make sure your workplace is safe and free from discrimination. So firstly, make sure training is thorough, engaging and effective, containing relevant examples to your business, and perhaps make it interactive so it's more interesting. Like I've put on the slide, box ticking is not enough, and refresher training is essential. Don't let it become stale. Take grievances seriously and investigate. This demonstrates that you take harassment seriously in the workplace, and it should act as a deterrent. Spot recurring issues and nip them in the bud. We heard from Jo the dangers of not getting on top of jokes about an employee who was menopausal. If you become aware of inappropriate banter in the workplace, don't leave employees to it and hope the issue will clear up. Get in early to see if anything is needed. Managers must react promptly and follow up, and training should be specific for managers to cover that as well. Demonstrate a genuine commitment to equality. Do your employees actually believe it's important to the business? Are there any schemes you can sign up to or causes you can support which demonstrate this? Foster an inclusive speak-up culture, and part of that will most likely be an effective whistleblowing policy and how you communicate it to staff. And finally, lead from the top. It's really crucial that you have the most senior leadership showing that they're invested, turning up to training, calling out inappropriate banter if they see it. Too often, it's those at the top that are the ones absent from training. If you'd like any assistance with any of these suggestions or anything I've talked about, do get in touch. We'd be very, very happy to assist. I'm now just going to hand over to Sasha, who has some immigration highlights for you to explain about recent developments and upcoming changes.
Many thanks, Grace. So I'm going to talk about what's changing in the immigration space and what we can expect in the course of this spring. I'm going to talk about the proposed additional visa routes that the government have told us about, but haven't expanded on in that much detail yet. And these are, as I say, expected to come into force during the course of the spring, but who knows exactly when, given the current international situation. But suffice to say that these routes are aimed at retaining the UK as a hub for global business. So, as I say, aimed at retaining the UK as a hub for global business, and these new routes are aimed to assist with recruitment shortfalls. In particular, I'm going to talk about the global business mobility route, the new scale-up visa, the new high potential individual route, and changes to the innovator route, which already exists. I'm going to touch on business travel, business visitors, now that we are seeing hopefully the end of the pandemic and people are traveling more. What should employers be thinking about? And I'm also just going to talk about the changes in the obligations on employers on right to work checks. Can I have the next slide, please? So first, the global mobility route. So as I say, 2022 is shaping up to be a year of big changes in the business immigration space. And one of those changes is the Home Office's commitment to introducing these new visa categories aimed at self-employed individuals and at businesses. Giving the idea being to give those businesses more options to send their staff to the UK. The global mobility route's one of those, and that the first thing to say, which is important, is that it's intended to operate under the current sponsorship system. So you need to be, in order to take advantage of the global mobility route, a license to sponsor. You need to have a sponsorship license to be able to use this route. The idea is that this route is going to incorporate and reform existing provisions and categories of immigration rules, particularly for intra-company transferees. Now, those are the individuals that are posted from an office abroad to the UK, and it's much more simple and straightforward and less expensive actually to make an intra-company transfer application than a general skilled worker, so previously known as Tier 2 application. So, for example, intra-company transferees don't need to demonstrate that they can speak English to a required standard. It's easier. The idea behind the global mobility route, it's going to allow businesses to transfer intra-company transferees and allow them to stay permanently in the UK, something they can't currently do. And so those are loosened requirements that are going to apply also to intra-company graduate trainees. And The idea being, as I keep saying, more flexibility, avoid business interruption. Similarly, sole representatives of overseas businesses, that route is going to be amended. Currently, overseas businesses are able to send one member of staff to the UK to set up a branch or subsidiary here. And as such, it can take time to set up a viable UK business. But under the new global mobility route, businesses will be able to set themselves up in the UK more quickly, because it'll permit a team of up to 5 employees to set up business in the UK rather than just one. So it is quicker. It is easier, but remember, this is not a route that allows non-sponsored employees to come to the UK. You have to, as an employee, be sponsored by a licensed business before you can apply to come here under the Global Business Mobility route. Okay, next route is the scale-up visa route. And this is the route that the Chancellor talked about in the budget last year that's supposed to help the UK's fastest growing businesses to access overseas talent. It's intended to attract highly skilled workers to the UK. The rules haven't been made entirely clear yet. The precise criteria need to be clarified, but we do have an outline of the route. And most importantly here, this is an unsponsored route. That means an individual doesn't need to have a job offer from a licensed UK sponsor to apply and to qualify under this route. They, can come on their own accord, so long as they qualify. It's intended, as I say, to enable highly skilled and academically elite mobile individuals to come and to work for a recognised UK scale up business. And what is that? So the requirement to qualify as a scale up business, you need to be able to demonstrate to the Home Office as a business that the business has an annual average revenue growth or employment growth of at least 20% over a 3-year period. And that's one of the eligibility criteria. Another of the eligibility criteria, the business that you're coming to join needs to have a minimum of 10 employees at the beginning of a 3-year period. So there need also to be a minimum salary paid to the employee coming under a scale-up visa, under the scale-up visa route, and that minimum salary is currently slated to be £33,000 per annum. That could change. Finally, also important to remember, anyone coming under the scale-up visa route will need to meet the English language proficiency requirement. So the government have promised that they're going to introduce a fast-track verification process for this route, but the details are still under wraps, so we'll have to update you when that becomes clear. Cover the next slide, thanks Jess. So the next route is the high potential individual route, and this is the route that is arguably one of the most exciting ones, but it's currently the option with the least information available. And again, it's designed to encourage further investment, to attract highly skilled, internationally mobile individuals to the UK. As I say, details are still awaited, but advantages include the fact that it's going to again be an unsponsored route. So if you qualify as an individual and you want to come to the UK to work, you don't have to wait to have a job offer, and you'll also be able to switch jobs and employers, giving you a lot of flexibility. The fact that it's unsponsored is obviously going to cut costs and bureaucracy. It makes it easier for applicants to secure a work-based visa without the immediate support of an employer. So what do you need to qualify? Basically, all they've told us so far is it's for applicants who have graduated from a so-called top global university. But they haven't actually confirmed what a top global university is. So we'll have to wait and see. But, the fact that you're able to extend your visa and settle in the UK means that this is potentially a very attractive route for people who want to come and live here. Next slide, please. Thanks, Jess. The next thing that the government have done, have also announced changes to the innovator visa route. Now, that's a route that allows an individual to set up and run a UK business effectively as an entrepreneur. It's replaced the tier 1 entrepreneur route, which is now closed. So the innovator routes for a person seeking to establish a business and they have to show that business is so-called innovative, viable and scalable. And it's an idea that they have generated or to which they've significantly contributed. So what the government have said now is that they're going to simplify this to introduce greater flexibility. They're streamlining the eligibility criteria to make it a little bit more accessible and user-friendly. And as I say, this is for those who want to set up and run a business in the UK. And by that, I mean something in that business has to be something that's different from anything that's currently operating in the UK market. That business or idea has to be endorsed by an approving body, known as an endorsing body. So a body like, I don't know, TechNation or the Royal Society or something similar. And additionally, an applicant's currently expected to have £50,000 to invest in that business. And they have to show that they're going to be playing a key role in the management and development of the business. And the government's proposed changes to this to give it greater flexibility. So the business eligibility criteria are going to be simplified. All applicants are going to be required to do is to show that their business venture has a high potential to grow and add value to the UK. And that's obviously very wide. So there's, much opportunity there. There's also going to be as they call it, a lighter touch endorsement process for applicants whose business ideas are particularly advanced already. And very importantly, there'll no longer be a requirement to have at least £50,000 to invest in the business. You can come and invest less or even nothing at all, so long as your idea meets the eligibility criteria requirements. And finally, what they're saying is that anybody who's coming under the innovator route will be able to do work outside of their primary business as well as their primary business. And that's actually a real departure from the current rules. Next slide, please, Jess. So I just wanted to also talk about international business travel and what issues UK employers should be thinking about, because we've had a lot of queries about this now that travel's obviously starting to pick up following the relaxation here and in many other places of the COVID restrictions. And a lot of employers are keen to get back to face-to-face meetings and develop relationships with clients. So, coming to the UK isn't straightforward if you're coming to work here. There are a lot of hoops you need to jump through. But if you're coming literally just to attend meetings and you can show that you fall within the business visitor rules, you can come much more easily. But first, really importantly, think whether the employers who are travelling do have the requisite immigration permission they need. They need to be mindful of the limitations of the business visitor visa route. And the most important thing to say is that those rules now, since Brexit, apply to EU nationals. It's very easy to forget that French, Germans, Italians, Spanish, etc. now need permission to come to the UK in the way that they did not before. So where any work goes beyond attending business meetings, those people, any non-UK national, will need to consider whether a skilled worker visa is appropriate or not. Just to reiterate, EU nationals no automatic right to be or work in the UK. They need to have permission to be here. If they're generally only going to be permitted to spend up to 6 months in the UK for tourist or business purposes. And I would caution employers against sending them here very regularly, even just to attend meetings, because the more they come, the more likely they are to be questioned. Also, for business travel into the EU, Brits actually are able to benefit from the so-called Schengen visa waiver, meaning they're able to spend 90 days within a 180-day period in the EU or Switzerland for tourist or business purposes. But it needs to be noted that the rules do vary from country to country. So it's very important that employers seek local law advice to be sure that their employees' activities fall within those permitted by the countries they intend to visit. Just a very brief word on COVID testing as well. I mean, obviously, these have now ended in the UK, requirements to fill in passenger locator forms and get tests, etc. But make sure that you do understand as employers what the requirements are for anyone going anywhere else, because there's still there are still testing and quarantine requirements in place in some countries. Just to sum up then, key takeaway for employers: consider the purpose of an employee's trip well ahead in order to ensure that there's enough time to apply for the correct visa, because ultimately failure to have the correct permission to come to the UK, for example, can result in an individual being held by immigration, denied entry. It can result in significant reputational and financial harm for employers, can even have an impact on your sponsor license if you're an employer with one of those. And individual managers and officers of the company can even be held personally liable in certain circumstances if they are allowing someone to come to the UK to work that does not have the permission to do so, or if the immigration authorities consider that they're coming to work. Next slide, please. So just finally, a quick word on right to work check changes. So these are going to be familiar to all of you, remembering that all employers are at risk of civil penalties if they allow people to work without carrying out the basic right to work checks, and those employers are found to be working illegally. So the first thing to say is the Home Office has extended its deadline for the expiry of COVID adjusted right to work checks, and that's allowed people to employers to make those right to work checks online without actually having to be present with the employee. But in the meantime, so therefore employers can conduct document checks by video links, and they can also access the Home Office online checking service, and they'll be able to do that from the 6th of April. That will apply to those with a biometric residence permit or a biometric residence card. Also important to note is the introduction of this identification document validation technology, which is coming into play from the 6th of April. It can be used to check the status of those with British or Irish passports. We're going to be provided with a list of approved identity service providers. And as soon as that comes, we'll certainly be publishing it on our website and elsewhere. But I guess the important thing to say here is that employers should ensure that those conducting right to work checks are updated with, or your internal onboarding processes are updated. The Home Office are moving full speed ahead with fully digital right to work processes, and we'll keep you updated as those change. So I'll just touch very, very briefly on a couple of final things. The challenges posed by the Ukraine crisis, I guess everybody's probably been following this. I mean, the Homes to Ukraine scheme was launched yesterday, and that will allow named individual UK sponsors to nominate a Ukrainian or Ukrainian family to stay with them at their home. I mean, previous to this, there was no way that you could do this unless you were actually a family member of a Ukrainian national. Now that's no longer the case. You can actually ensure that that your name is on the list, and you will be contacted if you have room to host a Ukrainian family or a Ukrainian national. The list is up and running now. Let's see how it works. And it used to be, as I say, that if you were just here as a skilled worker, for example, a Ukrainian national skilled worker, you couldn't invite family members. That's now changed, because you're going to be able to put your name on this list. Final thing I just wanted to talk about was alternatives to the tier 1 investor route, which, as you will be aware, perhaps, ended was a route that allowed people to come and live in the UK upon investment of £2 million. There are alternatives to this. Think about the skilled worker route, think about the sole representative route, think about the routes I've just talked about in the course of the, in the last few minutes, the business mobility route, the high potential individual route. The fact that the tier 1 has closed without warning, without notice, does not necessarily mean that those who were originally thinking of coming in that capacity can now no longer do so. So that's it. I'm very happy to answer any questions you have, or feel free to email us.
Thank you very much, Sasha, Kim and Grace. I'm conscious we're at 10 o'clock, but there are a couple of questions we might be able to cover really, really quickly. Sasha, are EU nationals visiting the UK for meetings expected to be meeting a UK business only?
No, not necessarily. I mean, the issue is with them coming into the UK. Is what they're going to be doing here has to be, they have to ensure that they can meet the requirements of the business visitor rules. If that means meeting a non-UK business, that's fine. So long as that what they're doing isn't working, then they will qualify under the business visitor rules.
Excellent. And just one other on the immigration front, return to work checks. Can a recruitment agency carry out a return to work check on behalf of an end employer?
I mean, yes, but the end employer, is the person who is going to be, should the Home Office knock on your door, they're going to need to know that the person sitting in your office has undertaken that right to work check as well.
Yeah, thank you. Quick one, Kim, the Microsoft Global Study, 41% global attrition. Do you know what the size of the study was?
Yes, I do. So it was, the survey was carried out by 30,000 people in over 31 countries. But then what Microsoft did was supplement that with sort of data over trillions of their products, and also sort of LinkedIn as well, so that was sort of supplemented. So survey 30,000, but lots of other data being fed into that.
Brilliant. So we've also had a question about whether for standard office work that's been done well for 2 years, what are the legal grounds for refusing a flexible working request for full-time home working? Well, obviously, although work might have been done well over the past 2 years, I think it's recognised by many employers that there are distinct advantages for people to be in the office. That might include training, interactions with colleagues, efficiencies, etc. And those are going to vary business by business. Now, under the flexible working regime, there are kind of 8 specific grounds on which you can refuse a flexible working request. And they include things like impact on performance, the impact on quality, the impact on sort of other people, and the ability to deal with customer demands. So what you would be looking for in relation to any request is whether your kind of reasons for wanting to refuse that request fall within any of those 8 grounds. If they don't, then you shouldn't be refusing the application, but if they do, then you can reasonably and legitimately refuse that application. So very worthwhile sort of going back to the underlying law here and just checking which grounds you might fall under. We've also had a question about ethnicity pay gaps and policies, whether policies are fair that focus on Black employees. I think that's a sort of very big topic. Obviously, as you're aware, I think there was a session of the Women Inequalities Committee in January, and the government is still sort of holding its counsel on when they will respond to the recommendations of that committee about ethnicity pay reporting. I think we don't really have time to do that justice now, but if it's an area which people are interested in, and certainly when we get some better clarity over exactly what the government might introduce, that will be a topic that we will deal with either in these sessions and also on our HRLaw offering. So thank you, and thank you also, I should mention, David, really thanks for your comments that you've been put up, some interesting observations. We'll end it there. Thank you for joining us. Hope the day continues to be happy and sunshiny for all of you. Look forward to introducing, to meeting you all at the next webinar, and we're working on the possibility of actually some in-person events. So it would be lovely to actually meet some people in person too over the coming months. Thank you very much all.